And here I'd like to give you just some practical advice of how you can manage costs. So we've just seen it. The major cost item are the lawyer's fees. And because lawyers still today are working mainly on an hourly fee basis, if you want to limit costs of lawyers, you have first to limit or control the length and the complexity of the proceedings. The second point that can be quite important are the experts' fees. And here, as I mentioned before, I'm talking here about technical experts, accounting experts, or legal experts. And if you want to limit the costs, the first thing to do is to limit the number of experts involved and also the depth of involvement in the proceedings. And lastly, the arbitrators' fees. And here, of course, if you want to control that item of cost, you need to control the numbers of arbitrators.
An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. From these two options, we can see that there are two types of arbitration agreements. One for existing disputes, and they are called submission agreements or compromis, to use the French terminology, and one for future disputes. Those are called arbitration clause or clause compromissoire. The first would commonly be a self-standing agreement drafted specifically to serve the purpose of agreeing to arbitrate an existing dispute, while the second would commonly be a dispute resolution clause in a contract designed for a business relationship rather than a dispute. The literature says that the two types of agreement are different, but they don't have to be. They may differ in content, as an agreement for an existing dispute can be more focused, designed to suit the needs and characteristics of a known issue.
Just stepping back about what party autonomy is, arbitration goes back a long way, as you probably know by now. Many things about arbitration have evolved, but one thing that hasn't evolved is the cornerstone of the concept of party autonomy, and that means freedom of the parties. You find it enshrined in various forms of subjects that the parties can agree to arbitrate. And importantly, and this is a document I'll refer to, you find it in the UNCITRAL Model Law on International Commercial Arbitration. This UNCITRAL Model Law, as I'll refer to in short, is a model statute adopted either in whole or in part by many states around the world. And the aim of the statute is to harmonize the framework of international arbitration as countries tend to adopt it and use it as part of their legislation.